watching the 5 o'clock news.
All right, joining us now to offer some insight into today's verdict is defense attorney Cary London. Cary, thanks for being with us.
Thank you for having me. So it was very upsetting to see that verdict, not because we like Trump or don't like Trump, but because 34 counts of falsifying business records on a case of first impression that 7 women and 5 men listened to, over 20 witnesses on, and deliberated for 11 hours to find him guilty of all 34 counts, I just don't think is giving the credit to the judicial system that it deserves. This was not the people of the state of New York versus Donald Trump. This was Alvin Bragg versus Donald Trump. He was out to prove a political point, and he proved that political point by getting a guilty verdict today.
So you think it would have been more convincing had they either had a split verdict or deliberated for a longer amount of time, in essence?
Exactly. I think there's no way that those jurors in 11 hours didn't go in with a preconceived notion or a preconceived idea of finding him guilty. For them to only deliberate on 34 counts with that amount of witnesses and come to a verdict of guilty on all 34 counts in that short amount of time shows me that those 12 jurors did not go in with an open mind. Those 12 jurors went in with a mind to convict, because you have to understand the entire prosecution's case was circumstantial. It was the rain example. Right now, there are no windows in the studio, Steve. We can't see it's raining outside. If somebody were to come in with an umbrella that was dripping or a rain jacket or boots, you could say it might be raining outside. That was the entire prosecution's case. There was no smoking gun in this case, which is why I don't see how they came to a verdict that quickly.
However, somebody can be convicted on circumstantial evidence, as we've seen throughout the years. Talk to us about what happens behind closed doors with the jury. They've received over 50 pages of jury instruction. However, they're not allowed to bring that back into the deliberation room. What do they do?
So when they go back, the foreperson is the person who's the juror number 1. And that person, no matter who they want to be the foreperson, whoever was selected as juror number 1 is the foreperson. That person's in charge of writing notes. The reason the judge doesn't want to give the law to the jurors in the back is he doesn't want them dissecting every single word and taking their own meaning on what it could mean. He wants them in the courtroom listening together as a group to the actual charges. And taking an hour to read jury charges is standard on every criminal case. This was 34 counts, so it was a little longer, but that was absolutely standard in this case. Any readback they want, the stenographer gets on the witness stand and actually reads back the testimony, and any law they want read back, Judge Merchant reads back.
All right, and I want to ask you the same question I asked Arthur. As a defense attorney, we know there's going to be an appeal to this for certain. Where does it go from here, and how would you defend it if Trump was your client?
So the first thing that happens is he'll be sentenced on July 11th to either a conditional discharge or probation. He's not getting jail. We know that because the DA's office did not ask for him to be put in today. Most times if you're convicted of a felony, the DA's office will ask that the defendant be put into jail. That didn't happen today. So we know he's not going to get a jail sentence on July 11th. The next step is perfecting the appeal. This is a case of first impression. No one's ever brought charges like this. No one's ever been convicted on charges like this. Judge Merchant told them that there were 4 different crimes that they could possibly think he committed without actually thinking he committed those crimes in order to find him guilty of the falsifying business records. So the appeal will absolutely be a strong appeal. Trump's going to have good lawyers. It's not going to be the same lawyers who did the criminal trial, because appeals lawyers are going to be separate from the criminal defense lawyers at his trial, and I believe this will be overturned on appeal 100%.
You mentioned the options that Judge Merchant gave the jury. Hey, for the secondary crime, you do have some options to pick from. There doesn't have to be a unanimous decision on that. Does that happen in any other case?
I've never heard it happening in the 20 years that I've been practicing criminal defense, because everything needs to be A to Z. You need to cross your T's, dot your I's, dot your lowercase J's. And him giving them that option, I just think opens the door to an appellate court to read this and say, we're throwing this out.
All right, Cary, let's pause you right there. We're going to go to Michelle Ross, who was inside the overflow room during today's deliberations.